morning. It's been a long ride, hasn't it? We've talked about a lot of things these almost 2 weeks, I guess. And I want to talk to you about you. And specifically how you do your job, the job that you've been assigned to do. There's really only one way that you can do the job that you have, okay? First, you've got to understand what the law is. You can't possibly do your job the way you want to do it unless you know exactly what the law is, okay? And if you know what it is, it's going to be a tool for you. It's going to take some of the weight off your shoulders. If you're like me, maybe this has been keeping you up. Maybe you're worried about how you're going to do this right. Well, that's what the law's for. It's here to help you, okay? The law is that no person shall be convicted of any crime unless and until each element of the crime as charged is proven beyond a reasonable doubt. And the burden of proof rests on the state to prove every material allegation in the indictment and every reasonable element, every essential element of the crime charged beyond a reasonable doubt. What is beyond a reasonable doubt? Some of you guys, I think, have served on civil juries. There was one or two who'd served on a civil jury before. If you were in a case in a civil jury, they'd tell you the standard is what's called preponderance of the evidence. That's like the scales of justice that you've seen. That just means just slightly tipping the scales. Okay, so that's how we make decisions in our life most of the time. Whichever one seems like the right one to go with, right? If you make a decision in this case based upon that, you haven't done your duty. You've missed it, okay? There's another standard of proof that's called clear and convincing evidence. Clear and convincing evidence, which is much higher than preponderance. That's the standard of proof if the government wants to take a child away from a parent. They have to prove their case by clear and convincing evidence. Clear and convincing. If you make your decision based upon clear and convincing evidence, you haven't done it. It's also the standard, by the way, to impeach a sitting U.S. president. Clear and convincing. Not enough. Government has to prove their case beyond a reasonable doubt. It is the highest known standard in the universe. Okay? It's been with us for hundreds of years. It is the only form, it's the best formulation that we could articulate to describe what's not mathematical certainty, because they don't have to prove a case to mathematical certainty. We're dealing with human beings here. Mathematical certainty is not possible, but this is the standard. It's as close to that as you can get. So the state had the burden, in this case, of proving beyond a reasonable doubt, number one, that her action, that shot, was not justified. They have to prove that to you beyond a reasonable doubt. Job one. Job two. If they can do that, then the elements as charged in the indictment. Each one of those. Let's start off with number one. Well, first of all, months and months of unhinged behavior. Months and months of unhinged behavior, Miss Bennett tells you. on the part of Miss Miracle. Constant aggression by Miss Miracle? Constant aggression? Lilia was all she talked about. She told you. That's true. It's the only thing she could talk about. Remember when the St. Simon's police officer came in here? It was one of the very first witnesses the state called to talk about that February 1st issue, remember? Did you have an idea what kind of trial you were going to be in for when you saw that? Did you know it? Could you believe that? That officer shows up at a scene from somebody calling the police. Knocks on the door. She pokes her head out. Is everything okay? Oh, yeah, it's fine. No, there's no problem here. Step out with me. Are you sure you're okay? She doesn't say a word. Not a word. She takes his hand and puts it up to her head. Not a word. And he feels a softball size injury to her skull. But he's a good guy. He's never hit me before. Well, he seems pretty calm. I guess we probably should get out of here. All right. Let's go. Did you see it? Police get called in this case. They show up. Who calls them? Miss Miracle. Over and over and over and over and over again. Over and over again. She's hysterical on the phone. She can't even explain what her name is, and she can barely get the address out. What does she tell those first responders on those videos? I'm so scared. Has he ever done this to you before? She doesn't say a word. All she can do is this. I thought he was going to kill me. I tried to feel for a pulse. He told me, don't go to sleep tonight. I was going to leave, but I was scared. Here we are again. He's a good man. He's such a good guy. I was going to move forward. He got so mad at me. I wasn't mad at him. I was just tired. If I moved on, he would kill me. He would shove that gun down my throat. I told him, let me sleep up there. The door downstairs doesn't lock. I should have gotten my car. I should have. It's on me. I should have left. But I have that stupid device on there. Right out of the chute. But then she hears he's still alive. She goes in that interview room. Oh, that interview room. Where they're telling her he's alive. Oh, I don't know. I'm not sure. I got this little form here for you to sign. Do I need a lawyer? Nah, you don't, no reason to have one. Oh, okay. Sure. We got this little form here. I'm supposed to have you initial that you understand every right. Nah, just here, just take this, sign this thing right here. And she says, she's giving every signal in the world that needs to be given to an investigator that there is a problem here. I don't know if I should tell you everything. Is he still alive? Can you just tell me, is he still alive? We'll find out here in a minute. if she's staging this whole thing, if this is a staged presentation, don't you think she's going to fire away all the things that he's done to her? Don't you think she's going to mention the St. Simon's incident with the softball injury and tell him that that's verifiable? She doesn't do any of that. None of it. None of this stuff makes sense if she's faking it. Why doesn't she even display the injuries? Folks, body looks like this. And she doesn't even bother to display for him what she has on her body. She's trying to make it seem like he attacked her. Wouldn't you think, hey, look at this, look at this. He has to notice, hey, what's on your arm? Oh, that's from when he grabbed me. She's not trying to push a narrative that he even attacked her, right? Why this? She knows how many shots are shot with the Beretta. She knows, right? She knows it without a doubt. It's not a question. Why does she tell him he only shot at her once? Does that make any sense? If she's staging the scene? Why keep telling him what a good guy he is? Why keep repeating that over and over and over again? If you want to know who James David Barron is, I think you found out when his son took the stand. That's what I think. Let me tell you why. Remember, his son testified that when Suzanne came to meet the family, that they were impressed. They liked her. She was into family, just like they were. Remember that? And they were like, okay, Dad, nice, right? She went on vacation with them to the beach. They're around her the whole time. And they like what they see. They get a call. He gets a call, December the 28th, on his phone, answers it in the night. And he's told this. She's in the bathroom. There's loud banging on the door. She is locked inside. And all she wanted to do was get away. He tells you that she said, I pulled a gun on your father. I pulled a gun on your dad, a man he has known his entire life. And what do they do when it's over? What did him and his brother do when it was over? You remember? They went and had a sit down with their father. They called it an intervention for him and his behavior. They've known her for 3 months. This happens, and they confront him. Compare that, folks, to Dana Gardner. Remember Dana, Suzanne's sister? Remember, she met David Barron. The whole family did. And they said, at that party, remember it was a January 18th party, they said something was off. Something was off about him. She'd been coaching Suzanne to try to leave this relationship, even though she didn't have a clue about the violence that was happening to Suzanne. Didn't have a clue. She's coaching Suzanne about how to leave the relationship. She gets 2 missed calls on March the 7th, 2025. 2 missed calls in the middle of the night. And what was her first thought? You heard the 911 call. She knew it. She knew it in her gut. This man's been isolating her. Something ain't right. And she knew it. All she talks about is Lilia, Miss Bennett told you. All she talks about is Lilia. All she talks about. There's one instance in these texts where she actually says something about what he's been doing. After the St. Simon's incident, she says, "You should be ashamed of yourself." What's his response? "You should be ashamed of yourself and how you reacted. It was you who acted so terribly to have some persons call the police." And her response immediately is to go, "Oh, yeah, I forgot about this one. You're so drunk you can't even talk." And then she immediately backtracks. "I fell and hit my head. I talked to them today. Don't worry, you're good. And I fell and hit my head. They heard me yell. I talked to them today. You did nothing. I held the door, you pushed, you fell. That's it. Everything's fine here." All she talks about is Lilia. You bet. Let's talk about Lilia for a second. Why is he sending these women money? Who are these women from this other country that he's just sending money to? Who are they? What do you think? What do you think? This is the only thing she's permitted to talk about. This is it. That's why it's all over the text. It's the only thing she can complain about. This. Did you notice this? Did you notice they put in all these texts between Suzanne and Evan and that they stopped on February the 15th? Did you notice that? Remember what happened on February the 16th? When he went cruising up to that same bedroom behind this same door. Comes down when he's darn good and ready. Wakes her up by tapping on her foot with a firearm. And she runs out of the house, gets into her car as he's running out the front door. We also know this is when she'd started communicating with Charlie English. What was she doing with every single text that she got from Charlie English, except for the last one? Deleting them immediately. State's medical examiner, I want to talk just quickly about this. There's an injury to Mr. Barron's bridge of his nose from the fall, and there's stippling around his face. Remember, the state's medical examiner said that that's pseudo-stippling from the material from the door that came through. Just want to remind you guys of that in case we get stuck on it later. Did you think this? Did you notice this? Did you notice when they called the medical examiner, were you thinking, hey, where's time of death? Were you thinking that? I missed it. I was like, why didn't they put that in there? Why didn't they put that in there? I was like, oh, it's this thing, this Hall County Sheriff's Office jail thing at 10:30. As though she's like, the murder happened, this murder happened hours ago, and she's searching for the jail and deletes it. Remember that whole deletion thing? They were more than happy. They were more than happy to put in this deletion and let you guys believe that that really happened. to make your decision. So you put your name on a verdict form. They're more than happy to give you that, this deletion. That never happened. She didn't even look at this on March 7th. It's from March 3rd. It was a tab that was on her phone. But they were happy to give it to you like that. And we had to have one of the best experts in the world, frankly, to come in here and tell you that's not correct. And what else did he tell you? 1:06 a.m., both of those phones are going up the stairs together. Both of them at the same time. Don't you honestly think that they have the ability to find that out too? Why did we have to do it? Didn't you want to know that? Why did we have to do it? Not only do the phones go up the stairs together, they don't come back down. They don't come back down. What does that tell you? We know for a fact she fires through the door. And what's the thing she does next? She has to run down into the garage, get a hammer, run back up the stairs, and hammer through this door to try to save this man's life. The phone doesn't make the trip. She doesn't call 911 yet. Why? She doesn't have her phone because he stole it. He just took it from her like he took whatever else he wanted to take. Just took it. We know for a fact he had the phone. It never made the trip back down the stairs. The state has suggested that Mr. Barron removes himself. He removes himself. That's what he does. He's such a calm person that he just removes himself from the situations. This guy's not removing himself. He's regrouping. It's part of his control. He comes down when he's good and ready. He took her phone back in September at the hotel, left her in the room, came back up and did what he wanted. He took her phone on March the 7th. And we can prove it, and we did. But they weren't going to give you that. We had to. She's 5'5". She weighs 120 pounds. This man is 6'3". He weighs 235 pounds. All he has to do is put his hands on her. It's over. And he did. And he did. If it's true, he's the removal guy, and he's got a 0.0 BAC on March 7th, why doesn't he walk out and go rent a hotel? He's got the only keys to the only functional car. If he's afraid of her or whatever, he can walk right out that front door if he wants to. He's done it before, apparently. Why doesn't he do it this night? Because he wants to come back down. He wants to take her phone, know she's isolated, and come down when he's ready. Don't close your eyes tonight. Don't you close your eyes tonight. This is super important to me. Maybe not to you guys, but I hope it is. What's new on March 7th, 2025? What's the new information? She's known about Lilia since December the 28th. What's new? What motivates her to do anything to him? What's new is the Charlie English text. He saw it. He became enraged and unhinged. Choked her, pulled her down on her knees, put his sex organ in her mouth, told her to suck it, and he just took his pistol and put it right on her lips. Did you notice that in the interview? You said he put it in your mouth. No, I didn't say I put it in my mouth. She corrects him right away. Right to my lips. My lips. There's something else in her mouth. We know she was trying to move on. She was talking to her sister about it. We know she's talking to somebody else. How does he react to her moving on? Well, with violence. She'd never seen him like this before. I want to talk to you about her statement, okay? I want to talk to you specifically about some law that you're going to get from the judge about that. The judge is going to tell you that in determining whether the defendant's statement was voluntary, you should consider whether the defendant was accurately advised of her constitutional rights and whether she clearly and understood and knowingly gave up those rights. If you failed to find she was properly informed of those rights and that she understood and gave them up, you must disregard the statement entirely and give it no consideration in your verdict. You have that power with that statement. You can do it. It's a garbage statement. It's not worth nothing. And let's talk about the investigator that got it. You remember when I was showing him the pictures of her injuries? And I said, hey, I'll show you the pictures of her injuries that I've showed you before, and you said accurately reflect how they were. Well, yeah, I said that before, but I mean, it was only open court. You handed them to me. I didn't have time to look at them or something. I even forgot what he said. I wasn't ready. I need all the information ahead of time or something. This is Mr. Firearms training. He's had like 2 hours of domestic violence training. He's never had a homicide case before in his life. And yet, in the area where he is the most trained, in firearms, I say to him, if somebody is over there shaking like this, they may not be so accurate with how their shot is. And he goes, they're still going to hit the target. You remember that? Wild. Wild. Remember Miss Bennett questioning Miss Miracle about her choices, her reasonable choices? What was the reasonable option? Your most reasonable option was to shoot the lock, she said. Your most reasonable option? As though in this scene, in this scenario, with what's been done to her in the past, with what he's done to her on this night, she's sitting there going, what is my most reasonable option here? I know, I'll examine the outside of the door and see if I can pick it with a screwdriver. It's insane. It's insane. That's not how a mind works in a situation like this. It can't. I want to talk to you about this 216 DUI arrest. This is super important. It's super important. Really is. That's the night that he went up to that room and locked that door and came down later, woke her up by tapping her on the foot with his firearm. And the government suggests to you that because there's a note in her phone writing out what happened on that night, that really, frankly, everything in that note's true. Can you imagine being so frightened of someone, so frightened of making a mistake and telling the truth about what someone had done to you, that you have to rehearse it in your phone? You have to rehearse it in your phone. And that's what she did. And we know, without a doubt, that what is in that phone, that note, is false, false, false. And you can know it straight to your bones. You want to know why? And I'm sure most of you are already here, but for those who aren't. In the note, she says, I get up and David's there. He comes down. I calmly go to the car. Goodbye. He's on the step. Goodbye. Goodbye. Really? We're going to talk about this one in a second. The last one. Why does he call her 18 times when she leaves? 18 times. And she's ignoring every call. "18 times. That happened. He came out of that door. He touched her with his firearm, and he tried to rape her anally. And she was so afraid to tell anybody about that she practiced her story in her phone. And it's false. Miss Bennett questioning Dr. Elkon, you remember? Dr. Elkon, what about this jail intake screening question from March 16th, the DUI arrest night? What about that? Doesn't it say on there, does the inmate have bruises? Doesn't it say on there that? Dr. Elkon's like, yeah, that's a screening question that somebody asks you when you get checked in the jail. Do you have bruises? No. Have you attempted suicide? No. Oh, well then that proves it. Sure. She wasn't dressed out. Nobody examined her body. And if they had, which is what was suggested to you, if they had, and checked off a form, do you honestly believe that the state wouldn't call that person as a witness? You believe that? Me neither. Dr. Elkon. Dr. Elkon. She's done 5,000 forensic examinations. 5,000. This is a person who worked for the state when people would claim that they were not guilty by reason of insanity. I don't know what I'm doing. Her job was to ferret out liars for years. Then she worked at the VA for 7 years doing PTSD work. She testifies for the state 75% of the time. 75% of the time. And she tells you Suzanne Miracle has PTSD. She has PTSD from David Barron's actions. What was the action? What was what they called the index event? Do you remember? It's a gun on the lips. Not in the mouth, on the lips. She's watched all of those body cameras. She's seen this behavior from Suzanne that you guys all watched, and she tells you that's an acute trauma response. There's nothing on there to suggest otherwise at all. Oh, well, she's being paid by the defense, they would say. You can't believe a word she has to say. Okay, fine. What about EMS? What about EMS? You saw them, they showed up. Who called them? The deputy. This person's having a panic attack. They show up, what do? They check her heart rate. Oh my gosh, it's elevated, we need to take you to the hospital. Can you imagine? There's a murder investigation going on. EMS shows up and says, we need to take this person to the hospital. That's literally what they're telling the police. Heart rate's elevated. This is what they do for a living. This person needs to go. Does Suzanne take that opportunity and go, great, yeah, I'm losing it here. My method acting has worked perfectly. Let's go to the hospital. Nope. Nope. Dr. Elkon told you if somebody's faking a mental health episode, that's what they want. They want somebody to go, okay, this is a mental health problem. She goes, nope. What is PTSD? PTSD is exposure to what? A life-threatening event. A life-threatening event. It's what it is. It's what it is. It's what she has. Guns at her lips. That's the event. And then we got into the, well, what about the counseling records at the jail? She says she doesn't like jail as well. Well, yeah, her lawyer told her not to talk at all about her case and the facts of her case, even with her therapist. And that's my fault, right? Because she didn't even get a chance to have that, to have that dealt with. Just held it. But what has she got? Hypervigilance, claustrophobia, hopelessness, frequent nightmares, increased heart rate and sweating, withdrawal, flat affect, the low monotone voice that they observed from her, and no eye contact. Remember that? That was the thing the deputy said. Well, I believed her at first, and she didn't make eye contact with me later on, and I thought maybe she was faking it. And the last one. I don't deserve anything better. That's what she was reporting. If Dr. Elkon is incorrect, if her testing is invalid, if her procedures are not up to snuff, why didn't the government call an expert to say, she did it wrong? If she's off, where's the person to say why? You didn't get it. Because it doesn't exist. Because it's correct. I want to talk just quickly about some of the things Ms. Bennett said. She told you that Suzanne went into self-preservation mode after the shot through the door. Did you hear it? She went into self-preservation mode. By sprinting down the stairs to grab a hammer, bash through a door, injure herself right here, trying to get through it to get to him. Self-preservation mode. And she picks up his gun, and she told you what she did with it. Twice. And we told you she was going to tell you that. Self-preservation mode. They say she put Mr. Barron's hand on the gun to fire the shot. Really? His left hand? He's a right-hander. She put his left hand on the gun? This is her genius plan? Okay. Does that make any sense? She staged the crime scene, they say. The world's greatest performance. Let me talk to you about the self-defense charge that you're going to get, okay? A defendant is justified in using force that's intended or likely to cause death or serious bodily injury. Justified in using force that's likely to cause death or great bodily injury when they reasonably believe that the use of such force is necessary to prevent death or serious bodily injury to herself or the commission of a forcible felony. What's a forcible felony? Aggravated assault by strangulation, which he'd already done downstairs. Aggravated sodomy, which he'd already done downstairs. And malice murder. Malice murder, which he told her he was going to do. Don't close your eyes tonight. I'll shove this gun down your effing throat. The point is that Suzanne doesn't have to intend to kill or shoot James David Barron for self-defense to apply. The force is the shot. She doesn't have to intend to kill him in order to have self-defense apply. She only has to reasonably believe that the force is necessary to prevent death or serious bodily injury to herself or the commission of a forcible felony. Forcible felony, strangle. Don't close your eyes tonight. Or aggravated sodomy, which is the forcible performance of an oral sex act. That's it. She doesn't have to intend to kill him. She just has to be concerned about these things. To boil it down even further, Self-defense means Suzanne's allowed to use deadly force if she reasonably believes it's necessary to prevent death, serious injury, or a forcible felony, even if the shot that killed Mr. Barron was not the outcome that she intended. She doesn't have to intend to be killing Mr. Barron to claim self-defense. And the state has the burden of proving to you beyond a reasonable doubt that her action, that shot, that one shot, was not justified. The judge is going to tell you this as well. He's going to tell you the defendant's use of deadly force may be justified even when there's not even been physical contact between anyone. There's no prerequisite for actual physical contact. We have loads of physical contact in this case, but you don't even need it. If the menacing action of the alleged victim is sufficient to create a reasonable belief that the defendant's life is in imminent danger, the defendant is in imminent danger of serious bodily injury, or a forcible felony is about to be committed, the defendant's use of deadly force may be justified. And the state has to disprove that to you beyond a reasonable doubt. You can think of it like this. At the top would be, let's say, we've proven to you beyond a reason, we, the defense, which we don't have a burden at all, but let's say we had proven to you self-defense beyond a reasonable doubt. Verdict would be not guilty. Even if you think it's probably self-defense, not guilty. Perhaps self-defense, not guilty. May not be self-defense, not guilty. Unlikely self-defense, not guilty. Probably not self-defense, not guilty. Highly unlikely self-defense, the verdict still, under the law, is not guilty. The only way you get to the guilty box is if the state's proven it beyond a reasonable doubt that it was not. That's the law. Remember, the state has the burden of proving to you two things. One, that it wasn't self-defense. We just talked about that. And if they get past that, if somehow they got past that, we go into here, each of the elements of the charge, offense, and the indictment. So let's talk about what those are. Malice murder. Here's the indictment. Unlawfully, with malice aforethought, causing the death of James Barron by shooting him. It's a malice murder charge. What does that boil down to? With malice aforethought, causing the death of James Barron by shooting him. Malice aforethought's the intent to kill without justification. In other words, without self-defense. Intent to kill. Deliberate intention to unlawfully take the life of another person. Deliberate intention. Abandon and malignant the heart. That's the malice murder count. That's what it boils down to. That shot through a closed door, that shot through a closed door where she can't see a single thing on the other side of that door. And the only thing she's got to know where he is hearing. And I guess, under the state's theory, once you take 3 or 4 classes at a gun range, you've become James Bond or Jason Bourne. I know where he is, and a kill shot through a closed door. It's insane. She tells him 1,000,000 times, I'm trying to shoot the lock, I'm trying to shoot the lock, I'm trying to shoot the lock off, I'm trying to shoot the lock off. No, government says, ignore that. Ignore that. She's intending to kill him through a closed door, and she can't even hear where he is. The only time she hears where he is, he's in the bed. Remember? He's on the bed. By the way, how would she sight this in from this height? When you're really trying to, right? She's 5'5". You guys are going to have this door back there. Play around with that. You're going to see this shot did not go down like that. It was like this. Intent to kill. Insane. Insane. Aggravated assault. We've only got 2 more, okay? Aggravated assault. This one's a little bit trickier, okay? And I'm going to go through it with you so you don't, I want you to make sure that you know it. Assault James David Barron by firing said weapon through a door in the direction of James David Barron. Assault is firing the weapon through a door. That's the act. The act is the firing of the weapon. Assault by firing said weapon through a door. You're going to have this in your charges, so I think it's on page 11 that the court will send back. An assault means either she intended to cause the injury by shooting him, meaning the same thing before. We got Jason Bourne over here shooting through a closed door. She'd have to be proven beyond a reasonable doubt to have intended to hit him with that shot. Ignore all her statements, you know, that she's trying to shoot the lock. She's not really trying to shoot the lock. She's trying to kill him through a closed door. She wants to hit him through a closed door. Of course, she waits till he's behind a closed door. He's down in the living room asleep. She really wants him dead. She waits till he's behind a closed door. Okay. Intended to kill him, actually intended to injure him, or the one that's in bold. The one that's in bold. Commits an act which places another in reasonable apprehension of immediately receiving a violent injury. Commits an act that places another in reasonable apprehension of immediately receiving a violent injury. What's the act? Remember, the act is by firing a weapon, right? So, commits an act by firing a weapon through a door which places another in reasonable apprehension of immediately receiving a violent injury. What does that mean? It means the government has to prove beyond a reasonable doubt that he saw or heard or perceived the shot after she shot it, but before it hit him. After the shot, but before it hit him beyond a reasonable doubt. That's literally what they have to prove. Yeah. It's insane. It's insane. And you remember this? Do you remember when the medical examiner testified? And I said, Dr. Zhang, would you expect that a human being would be able to perceive a shot after it's fired, but before it strikes them? And she said, she waited a long time. She goes, I don't know. That's what she said. And I said, wait a second now. Wait a second, Dr. Zhang. We talked a couple weeks ago on the phone, and I asked you this very same question. I said, do you think they'd be able to see it, perceive it, hear it before it hits them? And you told me you didn't think so. And she said, okay, but I don't know today. There is zero evidence of that. Zero. Forget proof beyond a reasonable doubt. Nothing. Nothing, and that's the law. This is very important. It is not enough to show that he's in a defensive position, which he's apparently selected, which is apparently the worst place, clearly the worst place in the world to pick when somebody's telling you they're going to shoot a lock off a door. But apparently he selected that in a defensive position. Doesn't matter. It doesn't matter that he's in a defensive position. Her saying, I'm going to shoot the lock off, I'm going to shoot the lock off, that is not what she's charged with. That's not it. He's got to perceive the shot after the shot, but before it hits him. No way. Last one. Last one. Damage to property. This is a property crime charge. Damage to property. They charge her with a felony of damaging property. Okay, what do they have to prove? They have to prove knowingly and without authority she interfered with a door. Knowingly and without authority interfered with a door. Also on page 11 of your charges, you'll see this. Without authority means without legal right or privilege. Without legal right or privilege over what? The door. That door. That door. That she owns. The government has to prove that she was without legal right or authority over a door that she owns beyond a reasonable doubt. And that she knew she didn't have legal right or authority over her own door beyond a reasonable doubt. It's insane. It's insane. But that's how they want to get you to a felony murder conviction on a property crime for a door she owns and that she would have absolutely no idea to know she has no authority over. Bottom line, folks, malice murder, they have to prove beyond a reasonable doubt she intended to kill him. Behind a closed door, through the use of her fantastic hearing and her expert marksmanship. Aggravated assault, they have to prove that Mr. Barron saw, heard, perceived the shot after it was shot, but before it struck him, based on zero evidence to that fact. And in fact, evidence from the medical examiner that she previously told me that she didn't think so. And with the damage to property, that she knew she was without authority, that she was without authority over the door, and that she knew it beyond a reasonable doubt. That's what they have to show. Now, the tampering charge, we don't have anything to say about that. Hang it up. If after giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, unsatisfied, then that is a doubt of the law, and you should find the defendant not guilty. That's what the judge can tell you. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty. It would be your duty to acquit the defendant. If you're going to find her guilty, it's easy, guys. It's easy. Evidence has to be so overwhelming, you don't have a choice. So overwhelming, you don't even have a choice. Is that what you got? Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Remember, they had two jobs. Prove to you beyond a reasonable doubt that she was not justified. No way was she justified. In no way, not even close. And if they do that, then you move on to the elements. And we went through those. I'll tell you a little bit more about some of the self-defense charges you're going to get, okay, from the judge. Evidence of prior difficulties or lack thereof between the defendant and the alleged victim has been admitted for the sole purpose of illustrating, if it does, the state of the feeling between the defendant and the alleged victim, or the reasonableness of alleged fears by the defendant. Right? The prior violence by Mr. Barron has been admitted so that you can know what she could expect to determine her reasonableness in her behavior. You may consider relevant evidence the defendant's been subjected to acts of family violence or dating violence in order to establish the defendant's reasonable belief that deadly force was immediately necessary. Immediately necessary. If she can reasonably know that he's coming out of that door whenever he's good and ready, that's how you can know how necessary it was for her to try to get her phone and get out of there. The defendant's use of deadly force may be justified even when there has not been physical contact between anyone. If the menacing action of the alleged victim is sufficient to create a reasonable belief the defendant's life is in imminent danger, the defendant is in imminent danger of serious bodily injury or a forcible felony is about to be committed, then the defendant's use of deadly force may be justified. He doesn't even have to have contacted her or touched her before. Of course he did. Her body's proof of that. Self-defense means she's allowed to use deadly force if she reasonably believes it's necessary to prevent death, serious injury, or a forcible felony, even if the shot that killed Mr. Barron was not the outcome she intended. Here's one. We haven't talked about this one yet. Judge is going to tell you that she is under no duty to retreat. A person who's not the aggressor is not required to retreat before being justified in using force that she reasonably believes is necessary. You heard a lot of evidence about whether or not she could leave that night, how she could leave, what method she could use. She could take that nice path down the road that you saw the video of, walking out the front door. She could go to a neighbor she doesn't know, except they gave her a basket once, so then obviously you can show up at their house at 1 a.m. and expect he's not going to be right on your heels. You can find a spare set of keys that apparently he doesn't even know where they exist on 12/28/24, even though he's got the only keys to the functional car right there in his pocket. And when we show the video of that little side room, you see any keys on the table? No. Took her phone just so she couldn't leave. That's why he had it. That's what it was for. But she doesn't even have to leave. She's under no duty to leave a home that she co-owns, and frankly, that she paid more for than he did. No duty to leave under the law. We showed you she couldn't, but she doesn't have to. Couple more things. And y'all probably won't get here, okay? But just so you know, felony murder is murder. Malice murder is one of the murders. Felony murder is another murder. They're all murder. Don't be thinking, it's something other than a murder. Felony murder is a murder. Last thing. And I shouldn't have put it up there because you guys are already reading it. But if somehow you get through all of the self-defense stuff and you guys feel like the government has just squashed that somehow beyond a reasonable doubt, there's absolutely no way she could have been thinking she needed to be free and safe and afraid. If you got past that, then you got through all the elements, right? You'd have this additional option, okay? The court's giving you an option of an involuntary manslaughter as a lesser offense. And I'm not telling you to do this, I'm just telling you this is one of the options after you've already gone through all the other stuff. Involuntary manslaughter, the defendant may not be guilty of malice murder in count 1 or felony murder in counts 2 or 3, but still be guilty of involuntary. For involuntary, the evidence must prove the defendant caused the death of another person without intending to by committing the offense of reckless conduct. What's reckless conduct? Causing bodily harm by consciously disregarding a substantial and unjustifiable risk that their act would cause harm to someone else. It's an unintentional killing through reckless behavior. It's another option for you. It's not what I'm asking you to do. It's not what I'm asking you to do. I told you at the beginning you weren't going to meet her. Remember? I told you. And you didn't. You didn't. And you won't. You still won't. This woman is gone. Almost as much as James Barron. Gone. And our position is, he did it to her. She was in fear for her life when she pulled that trigger, guys. And there's only 12 people in the world that have the power to give it back to her. They're all in this box. I have to guess what Miss Bennett's going to talk about when I sit down. I'm about to sit down. And then she gets to go again. One of the reasons that the government gets to go twice is because of the burden of proof. The burden of proof is so high for them. It's so high they get to go twice. So I got to guess what she's going to say, okay? And I don't know, but I'm going to just guess. It's going to be a lot of stuff about what happened after she fired the shot. Whole lot of stuff about what happened after. Probably all about what happened after. What happened after the self-defense doesn't change the fact that it was self-defense. It can't. You don't show malice by flushing shells down the toilet after a suicide attempt, or having a towel in the room, or making up a story to cover the fact that you had to flush them down the shelves. I mean, that you did flush them down the toilet. You don't. There's going to be some stuff I forgot, and I'm not going to be able to get back up. Like I said, I can't get back up and respond to the things they're going to do. No, it's not because I don't want to. Return verdicts and not guilty on all counts except for the tampering, please. Thank you.
Judge, would it be possible to get the jury just a brief 5-minute comfort break? 4:10.
Folks, what we're going to do, and I have no idea how long this will continue. I'm guessing roughly an hour and a half. So let's go ahead and take a break now, and we'll come back at 11:15. We'll have, assumedly, Ms. Bennett for the final conclusion remarks of her closing statements, and then I will give you the law, which will take about 20 minutes or so. With that, 15-minute break. Thank you.
I'm never going to remember.
Hearing?
No, the standard.
Oh. I appreciate everyone's professionalism. We're getting at about capacity, not quite there yet. I will say that if you work in the courthouse, court personnel, local lawyer, local paralegal, those types, if you are not sitting in the first 2 rows, I'm not requiring that you do that, but I ask that you do that. And I understand that you may not want to sit certain places. I'm not getting any of that. But if you happen to be in the back row and you happen to be court personnel or someone along those lines, you would be authorized to sit in the front row, and I think it would help the Sheriff's Department. Again, I'm not kicking anybody out at this point, so just want to be clear on that small request. With that, we'll be in recess until 11:15.